All right, good morning. The matter I'm calling is D1010 2023-40, State of New Mexico versus Hannah Gutierrez. Parties state their name.
Carrie Morrissey on behalf of the state of New Mexico. Good morning.
Good
Good morning, Your Honor. Jason Bowles from Ms. Gutierrez-Reed.
Good morning.
And good morning, Your Honor. Monica Barreras, also present for Ms. Gutierrez-Reed, who appears in custody. Mr. Bowles will be handling the hearing this morning.
All right, go ahead.
Your Honor, thank you. Judge, I wanted to touch on some principles in the Taylor opinion this morning and also the Godoy case in light of the jury instructions provided at this trial. Judge, at the time of trial, none of us had the benefit of the Taylor opinion, which, as this court knows, came out after the jury verdict. So I first want to talk about the jury instructions given, which this court is aware. There was a jury instruction given in 12A that gave the jury two alternatives connected by an and/or connector. And those two alternatives were the alternative theories for involuntary manslaughter that the state had advanced at trial. So the instructions provided that the jury could find Ms. Gutierrez-Reed guilty under either alternative theory connected by an and/or. Following the jury verdict, the Taylor opinion came out, and there's an important several principles in the Taylor opinion, and we cited that in the reply. The first one I want to read is from paragraph 9 of that opinion, which states that specifically defendants argue that the instructions listing the elements of essential conduct with an and/or conjunction provided for alternative ways for the jury to find the defendants committed child abuse without requiring the jury to unanimously agree on any of those alternatives. Applying a de novo standard of review, we agree with defendants. And Judge, then I want to go down to paragraph 16, which I've excerpted, where the court indicates that this violated our teaching in the Consul opinion, 2014 NMSC 030, that when two or more different or inconsistent acts or courses of conduct are advanced by the state as alternative theories as to how a child's injuries occurred, then the jury must make an informed and unanimous decision guided by separate instructions as to the culpable act the defendant committed and for which he is being punished. And so, Your Honor, our argument under that principle is that we had two different acts in this case. The first act being that she loaded a live round into a gun that was supposed to have inert ammunition. And the second act was that she did not allegedly perform an adequate safety inspection of that firearm. Based on those two paragraphs in Taylor, there should have been separate instructions, and there should have been the requirement that the jury unanimously find which act it was, which theory it was that they said she committed. The problem with the verdict under Taylor that we have at this point is we don't know which act the jury may have found unanimously or whether it was unanimous. And the other problem is that the special prosecutor specifically argued in closing that the jurors are able to find, 6 can find one act and 6 can find another, so there was no requirement that there be unanimity. That is precisely what Taylor is saying in paragraphs 9 and 16, that there has to be a finding of unanimity on that particular theory. Now, in Taylor, there were 4 alternatives. And so the court discussed there were 4 alternatives, and it was more confusing with the use of and/or when there were more than 2. That court did involve 4 alternatives. 2 of those alternatives involved CYFD policies, which they said could not be a legally adequate basis to convict. However, that was not the entire holding Justice Vigil announced, which was that anytime, and they criticized the use of and/or and said courts should consider abandoning the use of that instruction altogether. What they said is anytime you have 2 or more, going back to Consul, that there should be separate instructions to guide the jury to a unanimous decision. Now, that is how Justice Vigil announced Taylor in the Supreme Court. The Godoy opinion was not overruled in Taylor. Now, the court did discuss Godoy being a fundamental error review, because in that case, there was not a specific preservation. The state in their response indicated that our only objection at trial to the instructions was the use of the word reckless as opposed to negligent. But as we cited in our reply, and we had to get the trial tapes to delineate that, that was not our only objection. In fact, Ms. Barreras specifically made the unanimity objection, and it's laid out in our reply. Godoy involved a case where there were trafficking charge and a step-down possession charge for cocaine. So there in Godoy, the court said on fundamental error review, we don't find an issue with the jury not being given separate instructions because there's a step-down instruction, and we had one in this case. The step-down instruction is very detailed and explains to the jury, if you don't find the lead charge, then you go to the next step-down. So in that case, on a fundamental error review, the court said the jury didn't need any additional guidance because they must have found cocaine. So they found the possession charge in Godoy, but they didn't find the trafficking. But they did have language in that case where there are different acts, there are different ways in which crime can be committed. That's when, Your Honor, we are in this case, which Taylor talked about, when there's separate theories and those have to be unanimous. So that's why I submit to the court that Godoy is not applicable, that the principle of Taylor is applicable, that we need a unanimous verdict on the specific act. And so, Judge, I submit because of that, and none of us had the Taylor opinion at the time, but now that we do, I think this is a reason that Ms. Gutierrez-Reed should be entitled to a new trial with instructions that are different, that follow Taylor and they track Taylor's language, requiring a unanimous verdict on the specific act that she alleged to have committed.
Thank you, Ms. Morrissey.
Your Honor, in response, first I want to point out that the defense's initial motion was 2 pages long. So we did our very best to respond and kind of try to anticipate what we would be seeing in their reply. If certainly I would invite the court, if the court is remotely inclined to grant this, to request additional briefing, because to a certain degree, I feel like we got a little bit cheated out of an opportunity to fully respond, because the initial motion was so threadbare. I've never seen a motion for a new trial that was 2 pages. So having said that, in response to Mr. Bowles' argument, I want to point the court to, excuse me, I have a little bit of a cold. I want to point the court to Taylor paragraph 14, where the court in Taylor indicates, I'm just going to read it for the record, if that's okay. Using and or to separate 2 terms such as A and or B invites the reader to choose only A, only B, or both A and B. Thus, the reader is presented with only 3 options when and or is used to separate 2 terms. That's exactly what happened in Ms. Gutierrez's case. Is exactly what Taylor described in that very short paragraph. Taylor then goes on to discuss the very complicated scenario that happened in the Taylor case in terms of the jury instructions. So the court goes on and says, however, opposed to and or adding an additional proposition C can leave the reader guessing whether and or is intended to be placed between all propositions or only some of the propositions. And that was really the problem in Taylor. The problem in Taylor was they went beyond and or separating 2 alternatives, and they had 4 alternatives. And in addition to that, the acts that were outlined in those alternatives were just legally insufficient to support a conviction. You know, for example, if a daycare worker, a childcare worker doesn't follow CYFD policies or training, that in and of itself is not enough to satisfy the elements of the offense of that child abuse charge. So we certainly don't have that element in this case. In this case, we had two alternatives in 12A for the jury to consider, both of which were absolutely sufficient for involuntary manslaughter. It's my recollection that in closing, what I invited the jury to do, and this is a little bit different than what Mr. Bowles is suggesting to the court, what I explained to the court is you've got 12 and 12A. And between instruction 12 and 12A, there is unanimity is not required. I don't believe that I suggested to the jury that the options within 12A did not require unanimity. That's my recollection of my closing. I can see Mr. Bowles shaking his head. We haven't had the reason that when Mr. Lewis filed his response and he indicated that the defense didn't object to this was because he didn't have the benefit of the audio and the transcript. And that's one of my concerns is the defendant had the benefit of the audio and the transcript when they filed their initial 2-page motion, but they certainly haven't shared it with us. So I'm happy to provide additional briefing on this if the court thinks that that's necessary. In terms of the unanimity issue and the Godoy case, Taylor actually, as Mr. Bowles pointed out, upholds Godoy and the argument that, or the principle that unanimity is not required when there are two alternatives. And in this case, we had two alternatives, that being 12 and 12A. So while I appreciate the fact that the Taylor case may give guidance in the future to how to properly construct jury instructions that have and/or separators, the Taylor case actually has language that specifically supports what we did in this trial, there only being two options in 12A separated by and/or. So I'm a little confused about what the defense thinks the strength of their argument is, because when you read paragraph 14, Taylor actually is supportive of the way that we did it in Ms. Gutierrez's case. So for those reasons, we would object and we would ask the court to deny defendant's motion. And if the court has any specific questions for me or any concerns, I'm happy to address those.
Thank you. Reply.
Yes, Judge. First, Judge, the opinion in Taylor does say in paragraph 9 and 16, it doesn't limit that language to 4 propositions. The specific language in 9 and 16 is the Consul case when 2 or more different or inconsistent acts. That's specifically stated. And that's what Justice Vigil is saying in Taylor, is that the unanimity principle is the problem. The unanimity principle as to which different act. So it doesn't matter if it's 4 or 6 or 8 or 2. It's the idea that under our Constitution, there has to be a unanimous verdict as to the specific act. That is the issue that Taylor is stating. Now, I agree that Ms. Morrissey is correct in 14, that they talk about 2 or more, A or B and C. Now, the reason why they were going into that is because they were emphasizing that here, we not only have 2, we have 4, which made it more confusing. So it was more confusing in Taylor under those specific alternatives, but it didn't change the principle they're announcing, which is that when two or more, it has to be unanimous and it has to be separated. And Ms. Morris, it is hard to remember exact language, but she specifically said in closing, 6 of you can find one act and 6 in another, and we have those tapes. All of us, can request those tapes so we can get that transcribed if the court wants that, and we can make that part of the record. But the problem is this jury was invited to find a non-unanimous act and just conglomerate them. That's the problem that Taylor announced.
All right, thank you, counsel. So I do agree that your motion was very sparse and it just focused, your motion for a new trial was very sparse and it just focused on the and/or, and because we had a jury instruction in and/or, Ms. Gutierrez was entitled to a new trial. It wasn't until your reply where you flushed out issues that you had already stated regarding the unanimity aspect of things. I have read Taylor, I've read Gaudet, I've read Consul, I've read very many cases. I'm very aware of what occurred at trial. I'm very aware of the discussions that occurred on regarding the jury instructions. And I am denying your motion, Mr. Bowles, because I do not think that Taylor requires a new trial. In this case, I think that the issues in this case, the jury instruction in this case, are distinguishable from what happened in Taylor. I'm going to provide a written order outlining my reasons so that there's no misstatements of what I'm to make an oral determination. So I'm going to do a written order, but I wanted to let you know that I'm denying your motion for a new trial. I will put it in an order. You should get that on Monday, and we are staying the course on the sentencing.
Yes, Your Honor, and I had one additional request to the court in my motion, which was, and if the court were to address this at sentencing or to address it now, which was to consider release of Ms. Gutierrez-Reed pending an appeal and a writ that we would take for guidance from the appeals court and Supreme Court. And I just wanted to add to that, she didn't have any violations pending trial. She takes care of her father, who has been diagnosed with leukemia. She works and she has been in counseling. So she hasn't done anything wrong. She's not a danger or a flight risk. And I think there's an appellate issue that we have stated that we will raise, and a potential Supreme Court writ. And I just think it's unfair if there's any chance of the Court of Appeals or Supreme Court seeing it differently, that she serve her whole sentence on the chance that it could be reversed. So I'm just asking the court to consider that based on all those grounds and the fact that she hasn't had any violations.
Ms. Marcy.
Well, we do oppose Ms. Gutierrez's release. If this were like a motion to review conditions of release, I certainly would have been able to address my concerns with regard to Ms. Gutierrez and potential release. I'm opposed to it. Does the court want me to go into, I mean, I actually asked Mr. Bowles for proof of Ms. Gutierrez's employment history during the time that the case was pending, and any counseling and treatment that she has completed or participated in. To date, I don't believe he's provided me anything. So while Mr. Bowles wants to make these statements to the court this morning, these are things that I requested from Mr. Bowles, I think, over a week ago. I did it almost immediately after the trial so that I could be thoughtful in terms of coming up with a sentencing recommendation at the sentencing on April 15th, and I've received absolutely nothing. In terms of Ms. Gutierrez's full compliance with her conditions of release, I think there are some arguments to be made there if the court wants me to make them now.
The jury found Ms. Gutierrez Reed guilty. She is incarcerated at this point. She's facing incarceration time. Keep in mind, there was a death that the jury determined was caused by her. So I am not releasing her. All right. Thank you. We are in recess.
And Judge,